The next source we'll look at today is committee reports. And as we've already discussed a bit in connection with textualism, there are some schools of thought and some judges who really are reluctant to use legislative history, including committee reports, as a source of interpretation. So now we'll kind of put a little more meat on those bones. We'll see how courts sometimes do use things like legislative committee reports, and we will talk a little bit more about some of the objections to the use of legislative committee reports. So we've talked a little bit already about why legislative committees can be important. And as we've discussed a little bit, a piece of legislation gets introduced in the House or in the Senate or in a comparable body in a state legislature. And most of the time that draft piece of legislation is going to get referred to a committee within that body of the legislature that presumably has some kind of expertise over the subject matter of the legislation. It might get referred to more than one committee depending on what the legislation is. And then the committee is going to really be working with committee staff in kind of looking at that piece of legislation, and then often is going to produce a report on the legislation, referring it out, either referring it out for a vote or suggesting amendments to it. Of course, committees are often places where proposed legislation goes to die because there may be other political reasons or interests why that piece of legislation is not likely to pass, and it may just remain in committee and sort of never get out of committee. So you have all those things going on in committee, but it's not uncommon that a committee will refer out a proposed piece of legislation, perhaps with some proposed amendments and with some kind of report talking about the purposes of the legislation, how the committee is reading different parts of the legislation, and what it's supposed to do. So since these committees are supposed to have some expertise, and since they're looking at it carefully, and since they often produce a careful written work product reporting on it, those can be important pieces of legislative history, and they can be sources that sometimes interpreters, sometimes courts think are particularly important. Now, as we'll see, there are reasons why we might be skeptical of that. So the case that we're looking at is Blanchard v. Bergeron, and this case is another civil rights case and a statute that that's an attorney's fee shifting statute. So again, kind of consistent with a number of other sorts of cases that we've looked at in this case book. So notice that the statute says the court in its discretion may allow a reasonable attorney fee. The issue in this particular case is that the plaintiff has a contingency fee agreement with his or her lawyer. The contingency fee agreement, like all contingency fee agreements, says that the lawyer's fee will be some percentage, usually it's 1/3, 33.33% of whatever damages are awarded to the plaintiff. And as you know from torts class and from professional ethics class, these can be useful mechanisms. They can incentivize a plaintiff to bring a case where the individual plaintiff might not want to pay out-of-pocket fees based on some speculative recovery, and it allows plaintiffs' lawyers who are versed in different kinds of litigation to kind of assess a case and decide whether it's worth bringing. And there's all sorts of reasons why we might think that the possibility of contingency fee agreements are a good thing. There's reasons we might think it's a bad thing too. The problem is that there are cases in which the plaintiff's lawyer might spend a lot more time on the matter than really would be justifiable based on the ultimate contingency award if the attorney was actually billing hourly. Now, in certain kinds of personal injury litigation, that's sort of just part of the game. A plaintiff's law firm is going to have to realize and plan for the fact that it may handle some cases that really don't end up, in terms of the fee that's recovered, covering the overall cost of time. They might even handle some cases where they lose and get nothing. And that's sort of built into the system. It's how plaintiffs' lawyers have to assess what cases they're going to take and when they settle and that kind of thing. In the civil rights context, it's interesting because often the cases have a relatively low dollar value in terms of an ultimate judgment. In fact, the ultimate judgment really may be primarily about getting some kind of injunctive relief to stop an ongoing practice from happening. So there might be situations in which the contingency arrangement isn't really kind of the ideal from the perspective of thinking that we want lawyers to bring these cases. It might not always be the ideal mechanism for these kind of cases. So that's kind of the dynamic that's underlying this case. And the plaintiff in the case, the plaintiff's lawyer in the case, is arguing that the contingency fee arrangement should not determine what the reasonable fee is. The defendant in the case is saying, no, the reasonable fee, if the parties have agreed in a written agreement that a contingency fee is the arrangement, then that's by definition the reasonable fee, and that's all the plaintiff's lawyer should get. So there are two different committee reports. And remember, of course, that we have a bicameral system. We have the bicameralism and presentment clauses in the Constitution. So for federal legislation, it's a matter of constitutional necessity that a piece of legislation, is going to originate in the House or in the Senate, but it's a matter of constitutional necessity that ultimately the House and the Senate agree on common language, and there's a reconciliation process, and then it gets presented to the executive and signed. So it's not uncommon that related versions, even the same version of a bill, will go through the different houses and in different committees in each house and have different reports. And that's what happened here. So the Senate committee that looked at this said, well, in computing the fee, the counsel should be paid for all time reasonably expended on the matter. And that would suggest that you're counting your time and you're not counting, not limiting it to a contingency fee arrangement. Both the Senate committee report and the report that was produced in a committee in the House refer to a Fifth Circuit case that talks about what the reasonableness of a fee award should be. And one of the factors in that Fifth Circuit case, in a civil rights case, and one of the factors in that Fifth Circuit case is whether or not the litigant agreed to pay a specific fee, whether that's a specific dollar amount or whether that's a contingency amount. And that case, the Johnson case in the Fifth Circuit, said also that in no event should the litigant be awarded a fee greater than contractually bound to pay. So one of the questions is, well, what is Congress doing in these House and Senate committee reports? What does the Senate committee report mean in saying that it's all the time expended? What do the committee reports mean in referring to this Johnson case? Was Congress intending essentially to codify the rule in the Johnson case or not? What is Congress doing here? So the majority opinion written by Justice White says, well, yes, we have that limiting language in Johnson, and the committee reports do refer to that, but that limiting language is really just dicta. So we're not going to assume that the committee in Congress is adopting as a rule of law the dicta of a Fifth Circuit case. And we're really going to look at the broader language of the Senate committee report, which seems to say that all the time reasonably expended gets compensated, and therefore the proper interpretation of the resulting statute is that the contingency agreement does not limit the fee award. And Justice White says, this is consistent with the overall purpose of the statute, which is to encourage civil rights litigation, right? It's to give an incentive to a lawyer to represent a party where there's perhaps not a lot of monetary damages at stake, but there might be other important interests at stake which could be addressed by injunctive relief. So Justice Scalia writes a partial concurrence. Scalia agreeing with the result, but Scalia doesn't like the way Justice White gets to this result. And knowing as we do now a bit about Justice Scalia's textualist approach and his views about legislative history, that won't surprise us. But there's some good language in here that kind of encapsulates this view that Scalia takes. So Scalia says, look, this is crazy that we, the U.S. Supreme Court, are parsing through the language of a Fifth Circuit opinion to try to decide, is this holding, is this dicta? The Fifth Circuit is not binding on us as the Supreme Court, nor is the Fifth Circuit binding on Congress. Congress is free to, in light of something the Fifth Circuit says, Congress is free to adopt whatever rule it wants to adopt. So we don't want to go down that road. We want to just look at the language that Congress adopted. And then further, Scalia says, committee reports are particularly unhelpful. So the kind of classic presumption is they're really helpful because what they are is this committee that has expertise, that's looking really carefully, that has staff people who are trained, and is producing a piece of written work product that really gives a lot of information. But Scalia says, no, actually, what happens is, the case law references are not put in there by the congressperson. They're not sitting there poring over Fifth Circuit cases, he suggests. It might be a staff member, or it might even be a lobbyist, and many times those references are specifically put in there with the understanding that courts later are going to be looking to these reports to interpret the statute. So in other words, lobbyists are gaming the committee process to insert into the record, into these reports that courts often look at, stuff that they want to see the courts use in interpreting the statute, even if that's not really what the language of the statute is saying. So you see one of these reasons why Justice Scalia has some real concerns about the way these reports are used. As another good example of these kind of concerns, we can look at the Sinclair case in our book, which is a Seventh Circuit case. And notice that this is an opinion authored by Judge Easterbrook. Judge Easterbrook is another kind of key architect of the kind of textualism that Justice Scalia also espouses. So what's happening in this context is you have the bankruptcy code, and as you might know, Chapter 7 of the Bankruptcy Code is liquidation, the business is done, the assets are being sold off. Chapter 11 is reorganization. So the business is going to remain an ongoing concern. Some assets may be sold off, but some of the kind of debt obligations might be canceled by the court. Some of them are going to be renegotiated. It's all going to depend on, kind of the security interests and so on of the different creditors and what kind of debt it is. Well, there's a farm that goes into Chapter 11 bankruptcy, and subsequently Congress passes Chapter 12 of the Bankruptcy Code, which is a reorganization provision for farms that has some specific advantages for the farm. And the policy behind it obviously is to kind of promote farms and allow them to recover from financial crises and so on. And the question is, if the case has been filed as a Chapter 11 and now we have Chapter 12, can the case be converted into a Chapter 12 case? Because it otherwise would have been proper as a Chapter 12 case. So here the statute says the amendments, the Chapter 12 amendments, shall not apply with respect to cases commenced under Title 11 before the effective date of this act. So the statute, by its own language, seems to preclude converting it into a Chapter 12 case. So you wonder, well, how can the petitioner even get into court on this without it being a Rule 11 sanction, because the statute says you can't do it? Well, there is a conference committee report, and the report says it's not intended that there be routine conversion of Chapter 11 and 13 cases pending at the time of enactment of Chapter 12, but that courts will exercise their sound discretion in each case, only allowing conversions only where it's equitable to do so. So the question in the case, Judge Easterbrook says, is, well, there seems to be a conflict between the language of the statute and the legislative history reflected in the committee report. So given that there's this conflict, which prevails? And Easterbrook takes the classic textualist line here and says, I'm not going to look at this as maybe some kind of scrivener's error or some kind of some kind of legislative mistake or a clarification of some kind of ambiguity. What I'm going to say is, look, the report is just the explanation of the staff of that particular committee. The entity that actually votes on the bill is Congress, the House and the Senate. And then it gets presented and the president signs that text, the bill. The president doesn't sign the committee report. Easterbrook says a committee report could help a court understand the law, but if the report contradicts the text, the statute has to prevail. But he says, that seems to make sense, yet it seems like the Supreme Court sometimes does something else, and sometimes the Supreme Court allows legislative history to prevail over what seems to be contradictory statutory language. And Easterbrook says, what do I do with that? I mean, the Supreme Court seems to be telling me that at least in some cases I can use legislative history even if it looks like the legislative history is contradicting the language of the statute. What's a court to do? Easterbrook says. Well, Easterbrook tries to make a bunch of different moves about how and when we might use legislative history. And he says, well, I can't necessarily just use the plain meaning of the statute. Even as a textualist, statutes come in specific historical contexts, and the words always have a certain meaning. And it could be that a statute helps clarify the original meaning of the words. And in that kind of circumstance, yes, I might find it helpful. It might just clarify what the words of the statute is. But in textualist fashion, Easterbrook says statutes are the law, not just evidence of the law. This is one of those really interesting kind of debates about what is a statute as law. Are the words law, or are the words evidence of the purpose of the Congress, which is really what lies behind the force of law? Easterbrook obviously falls strongly on the side of the former, and he says, a revisionist history, might help me understand something in a historical context, but revisionist judging is not what judges are here to do. Even polling Congress for the opinion of different Congress members about what their opinions might be on a particular piece of legislation is not the law. If I go to each individual member of Congress, I'm likely to get, hundreds of different opinions about what the law ought to be and what it ought to mean. But what ultimately happens is that Congress enacts a text, and it's the text that is the law. And when the text is clear, then we're not going to look at whether there's any other reason to look at legislative history. The text itself is the law. And Easterbrook says, when I look at the text in this case, the text is clear. The text of the statute, notwithstanding the committee report, clearly disallows the conversion in this case. So some interesting notes after this case, which ask, actually, did Judge Easterbrook get it wrong? Here's what we might bring into play. Well, how does the particular text of a statute relate to the whole act? Remember that discussion of the whole act rule. Were there other portions of this statute that actually might have cut the other way, and where that might have raised ambiguities even for someone like Judge Easterbrook, in which case maybe that legislative history is helpful. And you can see that in note 1 in the text. Maybe or maybe not. Another kind of question that this raises is, well, if Scalia and Easterbrook and the textualists are right that it's easy to game a committee report, it's easy to put in language in the committee report through a lobbyist or something else that you might want to later influence a court, does that also happen with the language, the text of the statute itself? Does the language of the statute itself get gamed by lobbyists in order to influence how a court is going to then interpret a statute? I think in general, we'd all probably say, well, sure. I mean, to some extent, to the extent there's lobbying and interest groups behind statutes, which there always are, then the specific language is going to be at issue too. The question would be, though, at what level does that really matter? And in fact, if an interest group is able to get words enacted into law, well, fine, you've prevailed. But do you change that with interpretation through things, words or case citations or other things you get inserted into a report? Interesting kind of discussion, and you can see it talked about in those notes. All right, the last case in our reading for today is actually an English case, which is Pepper v. Hart. And we're giving you this case not because I'm expecting you to know English law, but because it's a good illustration of a jurisdiction that previously had a hard rule that said you don't use legislative history. And where that rule changed in this Pepper v. Hart case, and the debate among the judges in that case about whether it should change or not, or why or when. And it just highlights a little further about how or when or why we might use legislative history and what some of the issues might be about that. So I think it's a little bit hard to follow factually exactly what the dispute is in Pepper v. Hart. So the idea is that the government is providing tuition dollars to schools that are providing public education to people's children. So you have some degree of ability to select a school that your child goes to, and it will be the cost of it will be defrayed by the government. Those benefits that are provided by the government under English law are counted as income, and therefore they are taxable as income. And the statute says the cost of the benefit provided is going to be what's taxed as income. And then there's a definition in the statute that says this is defined to mean the expense incurred in or in connection with the provision of that education. And the issue that arises is that there are some schools that have extra seats. They have capacity, given the facilities and the teachers and all the other resources that they have, to add additional students. They can add new students without building a new building, without buying new desks, without hiring new teachers. So the marginal cost to the school is small, close to zero. So if you calculated this expense incurred in or in connection with the provision of the education, then the value of the benefit provided to the parent in terms of this dollar value would basically be zero. They wouldn't have to pay any taxes. But if you looked at the actual tuition dollars per student, then the benefit would be much higher, and there would be more significant amount of tax that would have to be paid. That's the issue going on in the case. So there is legislative history in the debates in Parliament that suggests pretty strongly that the expense incurred was actually meant to be the marginal cost, not the cost of tuition, but the marginal cost, so that in cases like this one, where the marginal cost was close to zero, there's really not going to be much tax. But the previous English rule had been that legislative history is inadmissible. And this is a rule with a long and deep tradition, a lot of which has to do with the fact that Parliament's an older institution even than Congress, for sure, and that debates happen, and that there's a reporter, when there's agreement on what the actual legislation is, there's a reporter kind of writing it down, and then enrolling it, literally rolling it and putting it, in storage, and that's kind of the law. So it has kind of deeper historical reasons. So of the judges deciding the case, there's agreement that the benefit should only apply to the marginal cost, but there's differences about whether legislative history is necessary or appropriate to reach that result. And Lord Mackay writes that, I think I can simply read the statute on its face without legislative history to get to this result. And I don't like the idea of using legislative history. This is contrary to our rule. And he says, the appellant argues that, well, we can be selective about this. We can use it only when we are confirming the meaning of the text as it is, only, or if the meaning of the text is ambiguous, or if the ordinary meaning seems absurd or reasonable. And so it's only limited circumstances under which we'd use it. But Lord Mackay says, yeah, but you know what? In any contested case involving a piece of legislation, it's likely that one or more of these conditions is going to apply. So I just think it's going to apply all the time. I think it's going to be too expensive, It's going to make lawyers do a lot more research than they otherwise would have to do. That'll increase the cost of litigants. The old rule should still apply. Lord Brown Wilkinson writes what becomes the new rule and says, well, no, actually, we should modify the rule to the extent that we're using legislative history as an aid to construction of legislation which is ambiguous or which would lead to an absurdity. He says that we should only allow it, though, not routinely, but only where the material clearly discloses the mischief aimed at, right? What the problem is that the legislation is trying to solve, or what the intent is in the legislation. And he further says we're going to limit it, we should limit it to statements of the minister or other promoter of the bill. So it's the legislative history only of the person or persons who is or who are really the prime sponsors of the bill. An effort here to perhaps try and limit some of the possible gaming. Lord Brown Wilkinson further says, yes, I agree that the statute is the actual words that Parliament has enacted, the law is the actual words of the statute, but Parliament never intends an ambiguity, right? We've seen this before in some of our discussion of legislative history in the American context, the idea that courts very often, even though we know when the sausage gets made it's really messy, courts are going to sort of as a principle of law say, well, we have to sort of assume that Parliament, Congress, whatever, doesn't intend ambiguity. And he further says, well, courts do this anyway. Courts often use legislative history or refer to it, maybe even without putting on the record that this is what they're doing. But if they're doing it anyway, let's kind of bring this out into the light and let the true intention of Parliament be known. And so he announces the test that if the legislation is ambiguous or obscure or leads to an absurdity, then we can rely on a limited set of material if those statements are clear. So this chart actually just kind of contrasts the different approaches in this case that Lord Mackay would have taken and the approach that eventually becomes the rule that Lord Brown Wilkinson takes. Now, when we get together in class, again, we'll look at some examples, and we can also talk a little bit about, well, is the Old English rule really the better rule? Is this current English rule announced in Pepper v. Hart a good rule, and do its limitations work? Or is the kind of mainstream American approach, which is really kind of ad hoc and depends on the judge and depends on what the source of legislative history is that the better approach? And we can talk about some of those distinctions, and we'll work through some examples when we meet together in class.